In November 2022, the second largest cryptocurrency exchange in the world collapsed in 72 hours. Not because of a market crash. Not because of a hack. Not because of regulatory action. Because of a balance sheet. A single document, published by a crypto industry news outlet, showed that Alameda Research, a trading firm owned by the same person who owned the exchange, was holding billions of dollars in FTX's own token as its primary asset. That revelation triggered a withdrawal run that the exchange could not survive. Within 4 days, FTX had filed for bankruptcy. $8 billion in customer funds were gone, and Sam Bankman-Fried, who had been called the next Warren Buffett of crypto, was under criminal investigation. This is the full breakdown of what the court documents show, what the SEC charges reveal, and how $8 billion in customer funds disappeared inside a company that was valued at $32 billion just 12 months earlier. Sam Bankman-Fried, known publicly as SBF, founded FTX in 2019 as an international cryptocurrency exchange. By 2021, it had grown to become one of the most prominent platforms in the crypto industry, with celebrity endorsements, naming rights to a major sports arena, and a valuation of $32 billion. SBF was simultaneously the CEO of FTX and the owner of Alameda Research, a cryptocurrency trading and hedge fund operation he had co-founded in 2017. The relationship between FTX and Alameda Research is where this case begins. FTX operated as a cryptocurrency exchange, a platform where customers deposited funds to trade digital assets. Those customer deposits were supposed to be held in segregated accounts, available for withdrawal at any time. They were not. According to the DOJ indictment and SEC charges filed in December 2022, Bankman-Fried and his co-conspirators had been systematically transferring FTX customer funds to Alameda Research since at least 2019, the year FTX was founded. The mechanism was a backdoor. Alameda Research had been given a special line of credit inside FTX's systems, an undisclosed arrangement that allowed Alameda to access FTX customer deposits without those withdrawals appearing as standard transactions in the exchange's records. That line of credit had no fixed limit. It was not disclosed to customers. It was not disclosed to investors. And it was not disclosed to the lenders who provided billions of dollars in financing to both FTX and Alameda. What Alameda did with that access is documented in the court filings. The funds were used to make venture capital investments, over $5 billion deployed into crypto startups and related businesses, using money that belonged to FTX customers. The funds were used to purchase real estate, approximately $300 million in property in the Bahamas, where FTX was headquartered, bought in the names of senior executives and their families. The funds were used to make political donations. Tens of millions of dollars contributed to political campaigns on both sides of the political spectrum, which formed the basis of the campaign finance conspiracy charge in the federal indictment. And the funds were used to cover Alameda's trading losses that had accumulated as the crypto market declined throughout 2022. By the time the balance sheet was published in November 2022, Alameda's primary asset was FTT, the token issued by FTX itself, a token whose value depended entirely on confidence in FTX continuing to operate. When that confidence collapsed, so did the token. And when the token collapsed, so did Alameda's balance sheet. And when Alameda's balance sheet collapsed, the full picture of what had been happening to FTX customer funds for 3 years became visible. The withdrawal run began on November 6, 2022. Within 48 hours, FTX was processing $6 billion in withdrawal requests it did not have the liquidity to fulfill. Binance, FTX's largest competitor, announced it would acquire FTX on November 8 to stabilize the situation. It withdrew from the deal on November 9 after reviewing FTX's financial records. On November 11, 2022, FTX and more than 130 associated legal entities filed for bankruptcy. Bankman-Fried resigned as CEO on the same day. He was replaced by John J. Ray III, the restructuring attorney who had previously overseen the Enron bankruptcy. Ray's assessment of FTX's internal controls was documented in the first bankruptcy filing and has since become one of the most cited passages in the history of corporate governance failures. He stated that in his decades of legal and restructuring experience, he had never seen such a complete failure of corporate controls and such a complete absence of trustworthy financial information as occurred here. The criminal charges were filed on December 12, 2022. Bankman-Fried was arrested the same evening at his residence in the Bahamas by the Royal Bahamas Police Force and extradited to the United States. The federal indictment charged him with 7 counts: wire fraud conspiracy, for the scheme to defraud FTX customers by misappropriating their deposits; wire fraud, for individual transactions executing that scheme; commodities fraud conspiracy, for misrepresenting to customers how their funds would be handled; securities fraud conspiracy, for misleading investors in FTX's equity fundraising rounds about the company's financial condition; money laundering conspiracy, for moving misappropriated funds through multiple accounts to conceal their origin; and campaign finance conspiracy, for making political donations using customer funds in violation of federal election law. 3 of SBF's closest associates pleaded guilty and cooperated with prosecutors. Caroline Ellison, the CEO of Alameda Research and SBF's former romantic partner, pleaded guilty to 7 criminal counts and provided testimony that directly corroborated the government's account of how funds were transferred and how the balance sheets were manipulated to conceal the transfers from lenders. Gary Wang, the co-founder of FTX and its chief technology officer, pleaded guilty and confirmed the existence and mechanics of the backdoor that gave Alameda access to customer funds. Nishad Singh, FTX's head of engineering, pleaded guilty and provided testimony about the internal systems used to facilitate the transfers. Their testimony formed the backbone of the government's case at trial. Bankman-Fried went to trial in October 2023 in the United States District Court for the Southern District of New York. He testified in his own defense. He acknowledged what he called messy accounting and huge management failures. He denied knowingly committing fraud. The jury deliberated for less than 5 hours. On November 2, 2023, Sam Bankman-Fried was convicted on all 7 counts. On March 28, 2024, he was sentenced to 25 years in federal prison and ordered to forfeit $11 billion. The sentence was one of the longest ever handed down in a financial fraud case in United States history. The FTX bankruptcy proceedings continued separately. John Ray's team recovered sufficient assets to announce in 2024 that creditors would be repaid in full, a rare outcome in a bankruptcy of this scale, made possible in part because the dollar value of recovered crypto assets had increased as markets recovered. What the FTX case demonstrates at its core is not a failure of cryptocurrency regulation, though that debate continues. It is a failure of the most basic principle of financial custody. Customer funds held in trust are not operating capital. They are not investment capital. They are not available for loans to affiliated entities. They belong to the customers who deposited them and must be available for return at any time. That principle is not unique to cryptocurrency. It is the foundational rule of every custodial financial relationship, from a brokerage account to a bank deposit to a crypto exchange. When it is violated, the legal mechanism that responds is wire fraud. Each transaction that moved customer funds without authorization was a separate count. Each communication that concealed that movement was evidence. And the combination of scale, duration, and deliberate concealment produced one of the longest sentences in the history of white-collar prosecution. The balance sheet that started the collapse was 4 pages long. The indictment that followed was 42 pages. The sentence was 25 years. In the next video we examine the Theranos case, and what Elizabeth Holmes's trial documents reveal about how a company valued at $9 billion was built on a technology that never worked. This is verdict paper. Every collapse has a paper trail.